what is needed to make archives meaningful in a legacy of transitional justice mechanisms. So, as the title says, the focus on our discussion will be on the legacy of such mechanisms, on the question what happens to archives after the mandate of transitional justice mechanisms come to an end, and what can archives contribute, how can they contribute to a meaningful growth beginning as processes, how can they contribute to the non-recurrence of violence and to reconciliation. We have heard this morning from Yasmin how many challenges and needs and gaps we are observing in this respect. It's an issue that has been neglected for quite a long time. That is not the case with the three speakers on this panel and the institution they represent, because this is an issue that is coming high on the agenda of all of their institutions. They are all engaged either in the implementation of concrete activities with archives or in planning of initiatives around archives, or also in the development of policy guidance around the role of archives in a legacy of transitional justice mechanisms. So this panel shall give us a chance to learn from the very concrete experiences from, on the one side, from the ongoing work on the archives of the former Equity and Reconciliation Commission in Morocco, but also from current discussions, considerations and initiatives at the International Criminal Tribunal for the former Yugoslavia, ICTY, concerning their legacy of their archives. And we will also learn more about the work of the UN, the policy development work and others, particularly also of the Office of the High Commissioner for Human Rights. We have about 90 minutes for our discussions. We first will have some presentation and discussion here among us on the panel, and then open up to the plenary. It's a great pleasure for me to introduce as speakers on this panel. On the one hand, to the very left, Mactar Ndoye, who is from the Office of the High Commissioner for Human Rights, OHCHR, where he works within the rule of law, equality and non-discrimination branch. Mactar is very familiar with this issue from different angles. He participated in the UN negotiations with the government of Burundi in the establishment of the TRC and the Special Tribunal. He also was involved in the preparation for the setting up of the TRC in Togo. He's also in charge of the issues of archives of human rights violations at the OHCR, and was, among many other things, involved in the drafting of an OHCR tool on archives and human report and tool on archives and human rights. Then beside him, Nerma Jelacic from the International Criminal Tribunal for the former Yugoslavia, the ICTY. She's acting head of communication, of media outreach and the web, it says here, and the spokesperson for Registry Chambers. She's also a former director of the Balkan Investigative Reporting Network, Bosnia and Herzegovina, has written widely on war crimes and post-conflict justice mechanisms. I hope you heard anything that I said. Then to my right, Asmaa Falhi. She's a program manager at the National Human Rights Council in Morocco, where she has been working for some time now, since 2007, the leader that preceded the Human Rights Council. She first was responsible or worked in the National Human Rights and Democracy Program. Later on was the head of the Archives Department, where she was responsible for setting up a program on history, memory and archives of human rights. And before that, she also worked between 2004 and 2006. She worked with the Equity and Reconciliation Commission as the head of documentation and records management group. So, Asmaa, I would like to start with you and your experience. And we know that the Equity and Reconciliation Commission lasted from December 2004 until end of 2005. That means that the Commission finished its work quite some time ago, and its archives are now still in use in the country. So it would be nice if you could give us a bit of an idea what we are talking about when we talk about these archives and how they have been used, what their role has been since the end of the Commission's work. A bit of a background.
Okay, thank you very much. Good morning, everybody. Happy to be here. Thank you for the invitation. The Equity and Reconciliation Commission, as you mentioned, worked from 2004 to late 2005, and worked basically on the period between 1958, after the independence, to 1999. So it worked on the past human rights violations that happened in Morocco that some used to call the years of living in Morocco. The experience of the Equity and Reconciliation Commission started with, before with the creation of an official body within the CCDH, within the Human Rights Consultative Council, which was called the Independent Commission for Arbitration, that dealt with arbitrary detention and forced disappearances, but only for an compensation, individual compensation, financial compensation point of view. So the human rights community within Morocco, NGOs within Morocco, were saying that this is quite a restrictive, wrong approach, and that we need a broader approach. That's how the discussion came up with the creation of the Equity and Reconciliation Commission and work. The Commission worked mainly on arbitrary detention, forced disappearances, deaths on social events or social riots that happened in these years. The question of archives within the Commission actually was present from the beginning. We started thinking from the beginning of the work of the Commission of the question and the issue of archives, and that's how we created from the beginning the Archive and Documentation Unit, which worked mainly on victims' files and the management of the flow of files within the different working groups in the Commission. We had 3 working groups: investigation group, preparation groups, and a final report, research and study groups, and then an ad hoc group for reports. So we created this unit to manage the flow because we took we chose the option of just having one file victim, and that was a very, very hard option to take because it meant that it had many risks. We've chosen this approach basically because we knew that we wouldn't be able to manage the flow of all the documents that were in the position of the Commission if we started making copies for each group. So we centralized the whole files within the documentation and archives, records and archives unit, and then created an information system for managing human rights violation, because the whole were done after that on these files, analysis work, and the work on the reparation mainly. The ERC, the Equity and Reconciliation Commission, faced a big problem, which was the lack and the chaotic conditions of archives, of national archives, and of archives of state and official archives. We just couldn't and didn't find really archives to corroborate presumptions or rigors that we're having when dealing with the cases of arbitrary detention. We based the work mainly on the complaints the victims filed, and we studied these complaints according to what the victim would say, with the philosophy that the buried of proof is often the state and not often the victims. And because we're lacking proofs and we're lacking archives, this doesn't mean that this wouldn't have happened. The Commission chose also to work with kind of archives that were not really considered as significant, mainly the archives of hospitals and morgues, and the oral testimonies of people that were in charge of digging, for example, in cemeteries and so on. We also had a big work on what we call the private hearings, because we also had public hearings that when people came and that were broadcasted, but at the same time we had private hearings with like very known, important people that we knew were having information about what happened, because they were either leaders in political parties or either in some specific groups. We started to work on archives in the ERC, and that maybe happened afterward, because we started the work of processing and classifying the archives. And because the lack of resources and the lack of human resources and financial resources, the main work of processing that has been made was on what we call the victims' archives, or the victims' files, the decision, the reparation, financial indemnization and reparation decisions, and what has been done on investigation. The rest of archives, which is the archive that is documenting the daily work of the Commission, unfortunately we couldn't really work on that type of archives. So the ERC, one of its recommendations was that his legacy of archives would go to the National Human Rights Council. At that time, it was the Human Rights Consultative Council, and for following up the recommendation of the Commission on that report. Of course, it was a set of recommendation, and the Commission linked actually the recommendation on archives, history, and memory. And because we knew at that time that we need to make that link, to make this archive significant. The Commission also recommended the creation of the national archives. At that time, we had the national institutions, the institution that was created in 1926, and it was not really doing a long time ago the work of preservation of national archives. So we knew that we were lacking a national institution and archive, and that because we're thinking that this legacy is a national legacy and that it has to be accessed at a broad level, and that the normal place where it has to be would be a national archive, we recommended the creation of national archives. The law was promulgated in 2007, creating the national archives. And unfortunately, we have to wait until 2010 to appoint the director and have an address. When I say an address, it means like just an address, because it doesn't have either the buildings or the place, and it's still actually. Maybe the good thing was that the CNDH, the National Human Rights Council, was the body in charge of following up the ERC recommendation. All the recommendation, and between the recommendation of archives, memory, and history, we were the custodian of archives, and we were aware at that time that, as I said, the normal place where it had to be would be the National Archives, but we needed at that time kind of an intermediary body that would do the work, prepare the archives for the institutions. And we still know, and we still think that the national archives are not really ready now for being the custodian of the archives, because giving them the ERC archives now would just be like telling them to put them somewhere. We know we don't have the resources. We know you can't. We know that you have other priorities. The second thing is that we wanted as well that the philosophy of this of the work of the commission, we didn't want to lose the philosophy of its work. And these type of archives are very specific archives. We are talking about them as being deposited at the National Archives, so they would be part of the state's archives, but still we haven't created the commission to do its work, and that's it. We created the commission to do the whole work of reconciliation, the whole work of telling the truth, the whole work of research of what happened, not historical research or not historical study, because the Commission on War is not where it wasn't its work, but prepare at least for the researcher and scholar the materials. And we don't want to lose this spirit, as I said. We still think we need, and I think we need to think about grassroots violation archives as something very specific, and that's something that came to do, let's say, something different. And we cannot just put them in the normal process of normal archives. It's not like an archive of Ministry of Foreign Affairs, or Ministry of Interior, or Ministry of Justice, or whatever. We think as well this archives with history and memory, and in that sense, we've at the CNDH had elaborated two programs, one on collective reparation program, and within this program, where we were local actors, and here where I think regional archives and local archives are important as well. Local actors could propose projects on documenting and preserving archives of region, of specific region that suffered from specific kind of repression. And the second program is the program of history, memory, and archives, where we try to find ways to promote the National Archives, to help the National Archives to be real institutions in order for it in order for us to be in the archives. We do the work of course, processing, inventorying the archives within the CNDH. We have like two main expertise on the ERC archives within the CNDH and on the audiovisual archives as well, because we have more than 500 hours of testimonies, which is like a real resource, real materials today for researcher. We have, and we may talk about that as well after. We had and we still have problems of access to this archive. We still have problems of resources, and we still have the problem of how we can disseminate these archives, and as well how we can make it a real legacy, but not only the archives of the Commission, but as well because we knew that the Commission creates archives, just the victims file, we have public, we have private hearings, etc., we have testimonies, but we know that other bodies, NGOs, specific people do have archives that are related to this period and to these facts, and that we need to kind of have a policy of acquisition to make these archives really meaningful. We may
I think this gives us already an extremely good idea how important it is to create the conditions to do the work. I mean, as you described, starting from setting up laws and the physical conditions, also the structures, the institutional structure, the landscape that is able to manage with such an issue. And I think it's an interesting initiative to create this intermediary body. Could you maybe, before we move on to the other examples and later discussion, say afterwards where these physically this archive is now located and who is using it?
Well, the archives are now located within the buildings of the National Human Rights Council.
That's where?
In Rabat, in Morocco, in Rabat, in the main, like not the main building. We have many buildings, and one of the buildings, two of the buildings actually, the archives are in both in two of the buildings, but in separate funds. We have funds of victims' files, and we have and testimonies, and we have funds of the program of administrative daily work of the ERC. So we have two separate funds just for us. The thing as well is that we had a following up committee of the recommendation, and this committee, in order for it to do the work based mainly on financial compensation and other means of reparation, they do have access to the archives.
And who are the people who are now currently using these archives, coming to the archives? It's
mainly people who are still working, and it meaning the staff of the CNDH and members of the CNDH who are still working on the following up of the ERC recommendation, because we're still having a real work on the committee recommendation. And they are still using the victims' file, they're still using the decision, they're still using some kind of archives. Other types of archives that were actually public at the time of the ERC are now kind of disseminated by the CNDH, like public hearings, thematic hearings, specific reports, specific studies that have been conducted. Like all kind of documentation that was public at that time, it's now redisseminated in another way. We also, for example, gathered all the movies, because we had in this period the work of the ERC, many projects as well done by NGOs and by artists, and we had this set of movies that had been made on this period that we are now as well trying to enrich the documentation of this process.
I hope we'll have some time to go a bit more in depth on this issue afterwards. Nerma, Jelacic, the issue of the legacy of archives at the ICTY differs, of course, in many respects from the Moroccan case. It's an international body, not a national one. The work is not finished, but it's in its completion phase. It produced an enormous amount of material far away now, stored from the societies concerned. So many complex questions and challenges arising, I think, with regard to how to use these archives once the tribunal finished this work. It would be interesting to hear from you a bit more how ICTY currently approaches this issue of the legacy of its archives and what is planned for the time after the completion of its work.
Okay, thank you, Anita, and I'm very happy to be here with you. And before I start, let me apologize for the sound of my voice. Obviously, I have a cold, so I'll do my best to be understandable and to put everything I have to say in 10 minutes, but you can stop me if I pass over that time. As Anita said, this tribunal has been amassing and creating archives and the record of the conflicts of the former Yugoslavia since its establishment in 1993. In fact, next weekend it will be the 20th anniversary of the establishment of the tribunal. Back then, in those early years, nobody really thought about how one day, when this ad hoc tribunal completes its work, these archives will be put to use not only in the region of the former Yugoslavia, but in the wider field of the international criminal and humanitarian law. However, the question of what will happen with the tribunal's archives was first raised over 8 years ago, as the tribunal started talking about its completion strategy. So not only finding the last remaining fugitives and finishing a huge amount of cases that it had, but also finding the mechanisms and the possibilities for the placement of the archives following the closure. Now, I won't go into details of the various studies that we have had done between then and now. Suffice it to say that, as Yasmin Suka mentioned in her keynote speech this morning, the final decision for now, and I would call it still a temporary decision, with regards to what happens to the archives of the ICTY as a whole, once its mandate is completed, is that they will be taken over by this mechanism for international criminal tribunals, which has already taken over the archives of the Rwanda Tribunal in Arusha and will take over the custody of our archives on 1st of July this year, when the Hague branch of this institution is launched. However, it is important to note that what the UN views as the ICTY archive includes all the administrative, financial and other records, and not only judicial record. And what is primarily of interest, especially for the people of the former Yugoslavia, is the judicial record that has been created by the tribunal, whether through its cases or through its investigations. And I want to make that differentiation between how the judicial archive is also divided. We have information that has been court-generated, if you will. So these are our transcripts, our judicial decisions, our judgments, motions, filings, etc. But there is also a huge amount of information that was court-gathered, or more accurately, mainly prosecution-gathered. And this includes really something that is of core interest, especially to the people of the former Yugoslavia and the other mechanisms of transitional justice that I had played there. And these include audiovisual records, intercepted conversations, videos of the massacres, photographs, statements taken from witnesses, artifacts taken from mass graves, etc., etc. It's a huge body of information. And I want to give you some statistics, just so you can have, or try and have an overview of how vast this information is. So what we have at the moment of physical records of the tribunal is 10,000 linear meters, which in electronic form is something that I learned recently, several petabytes of information. For the registry generated documentation, you have 5 million pages and over 70,000 courtroom hours of audiovisual record of testimonies and hearings that we've held. But when you move to the Office of the Prosecutor archive, which is important, and these figures that I'm going to include now are the ones that have been filed as part of the record, but also a lot of information that has not been filed because it was not used in the cases but still remains in the vaults of the prosecution. It is 9 million pages. It is 14,000 artifacts as part of the Office of the Prosecutor, and 10,000 carriers of audiovisual sound. And that splits into 1,300,000 documents, 3,500 CD-ROMs, which I must say these include, for example, which I find very important for the wider discussion of dealing with the past in Balkans, intercepted conversations that, millions of hours of intercepted conversations that were gathered by the local and national intelligence officers and international ones, 13,000 audio hours and 9,000 video hours, which are in OTP archives. So what we know will happen with all this for now is that it will be transferred to the mechanism for international tribunals, because The current estimates are that our remaining cases, and the ones that are in trial phase at the moment, are Mladic, Karadzic, and Hadžić. The last of those is expected to finish with the first instance judgment in 2015. However, the appeals cases of these three, as well as a number of other appeals that are already ongoing, will go on beyond that. And it is this body, the mechanism for international criminal tribunals, that will deal with the appeals. But not only that, this body will have to deal with the enforcement of judicial orders for the protection of witnesses, for the confidentiality of certain documentation. They will have to observe the enforcement of sentences of the people who are still serving their sentences at that time. So they will need to have access to this archive. And very importantly, they will be dealing with the requests for access to non-public documentation of the judicial record of the tribunal from the local courts in the region that are currently prosecuting war crimes. Now, it is already possible to gain access to confidential information from the tribunal by the national judiciaries by applying for the court, for the tribunal to review the need for the confidentiality orders to remain in place. But once, and that is at the moment decided by the judges serving at the tribunal, once those judges are not there anymore, it will be the mechanism that will be deciding on such requests. But I think it is very important to know that it is possible to also access that. But meanwhile, the information that is public, and the vast majority of the information that the tribunal and the archives of the tribunal is public, luckily is already available in the electronic and digitized form. I think ICTY has been very proactive in making everything that it produces and generates on a daily basis in a public form available on that very same day, whether by sending it directly to its mailing list recipients or uploading it on its databases. Now, what we are doing is to improve the quality of some of the older cases by digitizing the audiovisual records and the documentation that had been filed as part of trials. So the database is growing and will continue to grow as these cases nearing their completion and as they complete, and is already accessible and used by a vast amount of international public, but also people from the region. However, what we need to do, and what we have been working on in the last 3 years, is to see, knowing that the archive, the original archive of the tribunal will remain with the mechanism, and probably after that will remain in custody of the United Nations somewhere, to find a way to make at least copies of the publicly available archives available in the countries of the former Yugoslavia. And this is something that has come as a task for the tribunal from the Secretary General in 2009, when the president of the tribunal was asked to explore the feasibility of establishing something like information centers which would hold the electronic databases of the tribunal, provide assistance to the local people in assisting and research and searching those archives, and possibly play a wider role in the wider dealing with the past efforts that are ongoing in the region. And this is a project that is now known as the Information Centers Project, and we've done a number of consultations both with the governments and non-governmental organizations and international organizations and victims organizations in terms of the need and the interest for such a center to be established in the countries of the former Yugoslavia, but also how the ownership of these information centers, so to say, and the role these information centers should play. So the people we were consulting with were specifically asked about the role, for example, the government or the NGOs or the international organizations should play in the running, day-to-day running and management of these information centers, and as well as their creation, obviously. And also the role of the information centers, whether it should be just a pure archive database where people can come and ask for information, or whether it should have an outreach mode, outreach arm within it as well. So whether it should proactively involve itself in the dealing with the past mechanisms in the region of the former Yugoslavia. What we have come to, the stage we've come to now, I'll jump through the various stages that we went through, but it's been a very complicated process to work on, and that will take me 2 minutes, what we have at the moment is the interest expressed by the governments of Bosnia and Herzegovina and the government of Croatia for the establishment of the information centers of the countries in the former Yugoslavia. Macedonia has said that they are not interested in hosting an archive or having a copy or access to such information. Serbia has been very difficult in obtaining a definitive answer about this, but at the moment it is looking very negative. And Kosovo has not provided its stance on this question yet. Importantly, in Bosnia, because we are also asking whether information centers should only be established in the capital city of that country, or whether there should be multiple centers per country. And in Bosnia, of course, there was an interest in having 2 information centers, one in Sarajevo and one in Banja Luka. But what is the good news is that there was an unanimous support for the establishment of the information centers from each of the 3-pronged presidency members that we have in Bosnia and Herzegovina. So, and Bosnia and Herzegovina doesn't only want to have information centers that contain a computer with an access point to the database. They wanted to play a much wider role, to have exhibitions, to have legal trainings, to have outreach activities, to hold conferences, debates, and to continue furthering the reconciliation process there. So in Croatia, the interest we have is at the moment for the access to the archival point. So this is where we are at the moment with the information centers. I'm happy to say that we've also asked the governments, because I think it is important at this stage in the Balkan story of dealing with the past, that there is some sense of ownership from the government of this type of record that has been created, especially if you view how the tribunal over the years of its existence has faced many obstacles in terms of cooperation with the governments from the region. And the record that has been created needs to have the ownership from the government and the acceptance of that record, not only for the symbolical message that it sends, but also because it in a way can guarantee more of a sustainability than if we decided to pair up with the NGOs, where we would always be dependent on fundraising for keeping these centers running. So I'm happy to say in Sarajevo we have had a pledge from the mayor of Sarajevo, who has been tasked by the presidency to coordinate the efforts there, of space in the public library of Sarajevo that was famously burnt in 1992 at the beginning of the siege of Sarajevo, and which is now being refurbished by Bosnia and the international community, and is set to open 2014. Having said that, none of this will happen if we are unable to secure the funds for the startup of this project. The tribunal doesn't have the funds or the resources. Outreach has been tasked by the president to in a way coordinate the establishment of the centers, but again we are dependent on the donations, and they are fewer and fewer, and similarly the information centers themselves will be dependent on that. So I'm going to stop there because there are other ways in which we are using the archives at the moment, but maybe I can do that when we have a discussion.
Yes, and it seems to be a recurrent theme.
Yeah.
I see already this lack of funds and resources, so maybe this is also be an issue to go into afterwards. I mean, what you just described shows us also all the challenges are not only of a technical character, but this is also, or can be, a very contested issue also, and we might have time afterwards also to come back to this. But first, Mactar, OHCHR, and you yourself is playing an important role in developing and shaping international norms and standards and policy around these issues. Also has a responsibility or co-responsibility for some of the archives itself. So it would be interesting to hear from you a bit more about UN, the OHCHR's work on this, and where we are now with international standards.
Thank you, Madam Chair. I thank all the organizers for this invitation, which is the second one, it seems. And I recognize in the room lots of colleagues who help us building our knowledge on archives. Because as you know, we are not the real professionals as human rights officers, but we recognize around the year 2005 that something needed to be done. I recognize Trudy in front of me. Who help us a lot in building this knowledge, Yasmin also, and several others in the room. I wanted to talk about the role of archives, but I think Yasmin did it very well this morning. And as a matter of time, I will skip this part and talk about the status in the UN, how the progress are made, and our efforts at the field level to advance this archives issue. And as you know, the issue of archives and human rights is the subject of a growing attention by the United Nations since the first resolution on the right to the truth adopted by the Commission on Human Rights in 2005, in which the Commission stated that states should preserve archives and other evidence concerning gross violations of human rights and serious violation of international humanitarian law. The issue of archives and human rights has been the object of two specific reports by OHCHR, mandated by the resolution on the right to the truth. And as you remember, in 2005, we drafted the first study on the right to the truth, which recommended OHCHR to take into account the issue of archives. That's why we started at that time putting it in our mandate, and it's where all started. And we have also a report containing a study on best practices for the effective implementation on the right to the truth, in particular practices relating to archives and records concerning gross violation of human rights, and program on the protection of witnesses and other persons involved in trials connected with such violation, and a report on the seminar on experience of archives as a means to guarantee the right to the truth, that Trudy once again helped us during the seminar. Furthermore, in its most recent resolution on the right to the truth, the Human Rights Council has requested OHCHR to invite member states, United Nations organs, intergovernmental organizations, national human rights institutions, and non-governmental organizations to provide information on good practices in the establishment, preservation, and provision of access to national archives on human rights, and to make the information received publicly available in an online database. We have already sent out the request together with questionnaires to facilitate the collection of information, and some of you have responded positively to it. and we are grateful for that. Since the publication of the Joannet Principles, updated by Diane Orentlicher, the struggle against impunity has constantly progressed. In several parts of the world, truth commissions have been set up and completed their work. Judicial mechanisms such as ad hoc tribunals have been put in place. Numerous commissions of inquiry and fact-finding missions have been established. And all these mechanisms produce archives. And the latest development at the international level, in particular the operationalization of the ICC and the recently adopted International Convention for the Protection of All Persons from Enforced Disappearance, which is the first universal instrument which recognize a right to the truth for victims, encourage us to strengthen our effort on this issue. And managing archives, and in particular archives of human rights violation, if you want to do it properly, also involve providing all the guarantees to the victims, in particular their right to know and their right to the truth, but also their right to privacy and security. And maybe it's in these areas where human rights officer and the office of the High Commissioner has to work more closely with the professional archivists. And that's why we are favoring a strong partnership between the archival community and other relevant stakeholders. We start doing it with the International Council of Archives in Paris, and all the archivists now we know and who are now human rights specialists, as we tend to do, to be archivists also, was through the International Commission on Archives, and we are grateful for that. As we develop our work on combating impunity, which is a central objective of our strategy, we need to know how to deal with the records and archives of human rights violations. And we are sure, we hope that we will learn more during this conference, because there are new ideas. When we started in 2005, it was very nascent. And as Yasmin was saying it, in Sierra Leone, where we were involved, no one thought about managing archives. And I think based on that experience also, we try to improve our approach. And it was a lesson learned that we try. You will see it in the example I will give after that. Now we try to avoid this kind of neglection. Now I want to turn to, in our work, how the impunity principles have been put into practice with regard to archives, and try to respond to the question on how archives can be meaningful in a legacy of transitional justice mechanisms. As mentioned earlier, the question of access is treated at the political level, in particular when the opening of records is linked to transitional justice processes. That's why it is at the political level that we place our action regarding archives, as we believe that all steps to be taken regarding the use of archives by transitional justice mechanisms and societies in transition need to be strongly grounded through a clear, affirmed political will, which are provided in the legal text creating those transitional justice mechanisms. For OHCHR, making archives meaningful in a legacy of transitional justice mechanisms means setting the ground with our national counterparts, so that the issue of archives is an important element of the whole transitional justice package. In practice, OHCHR does it through awareness raising and training activities on the importance of archives for such processes, including the archives of civil society organizations. We do advocacy for transitional justice decision makers, including governments and parliaments, with the view to incorporate provisions regarding archives inter alia in the laws establishing the mandate of transitional justice mechanisms, so that the issue of legacy is taken into account at the beginning of all processes in which OHCHR is involved, but also reflected with concrete recommendation in the final reports of relevant mechanisms with follow-up procedures established to implement the recommendations of such mechanisms. In terms of awareness raising and training activities, in all processes in which we are involved, we used to conduct training on transitional justice in general. But more and more, we train on archives also, using the knowledge we gathered by all our experts I mentioned before. And this issue of archives is quite new, but quite important when we try to help a country setting a transitional justice mechanism. And these activities aim at informing national stakeholders on the state of art on this topic, often neglected by decision makers. We did it recently in Burundi, in Togo, in Yemen, and as well as in the context of regional and international conferences on transitional justice, such as the Yaoundé II Regional Conference on Transitional Justice for Francophone Africa, co-organized by Switzerland and France. In terms of achievements now, more and more processes in which we cooperate take into account the issue of archives. As a result of our advocacy role, the TRC in Togo, for example, which submitted its final report in April 2012, included a section on the preservation de la mémoire, which contains 8 specific recommendations on how to handle archives by the Commission. The long transitional justice process in Burundi also starts showing some positive results. OHCHR was part of the steering committee in charge of the national consultations, and we introduced the issue of archives in the national dialogue, and Burundians were effectively consulted on how they want archives of the TG mechanism to be managed in the future. And this was reflected in the report of the consultation, which provide for clear provision on archives, in particular in terms of access and preservation. And the issue of archives was completely endorsed by the drafters, because in Burundi now we have a draft law, and the drafters of the law take into account this need to take care of archives. And I was part of the committee who were drafting this law, and we were able to include a whole chapter on archives. And now the draft law in Burundi will be discussed in June, and we hope that being preventive and putting it in the draft would help in terms of legacy, in terms of management before, but legacy after. I hope these 2 examples shows how OHCHR try to inform people on the importance of archives, try to create the link between archivists and the national stakeholders. And it's funny that Asmaa be here, because I've attempted a lot to bring her in Togo at that time, and due to time constraints, she was not able to do it. But we cooperate with them in these efforts also to bring professional archivists, which commission we try to set up or when they function, and it's for us very important. Now I will talk about, to try to be short, the question of commitment, because what we try to do is to help states set up their mechanisms. We are trying to influence laws to have archival provisions, we can say, but the problem we face is the problem of implementation, because as you know, we are operating in countries where situations are still fragile, and forging political will is not easy. Forging political will is not easy, and we are in contexts where balance of powers are not clear. And Trudy used to say that all these things has to be decided by politicians, but how to bring politicians to open the records when some part of people want to close these records. Just to show the difficulty of our work when we are negotiating with countries, try to convince them, for example, that the Truth Commission, for example, need a strong mandate allowing him to have access to archives, for example, Secret Service, the army. It's not an easy issue, but it's our role as OHCHR and for the victims to grant all these mechanisms with strong mandate and which respect international standards and best practices. I will stop here, open for the discussion, but just hope that I show you our role when we start building processes and the role we have in influencing government, doing advocacy, and using also our status as UN to push countries to create really independent, credible mechanisms which have a strong mandate to tackle these kind of issues. I thank you.
To you, and the strong role and important role is obviously playing in raising the awareness and afterwards really working on with and on the decision makers to act on the understanding of the importance of this issue. There are so many issues that now would be interesting to discuss, but I would like to come back at the access issue and maybe first also, Asmaa, give you also a bit more opportunity to describe how is ensured that the people most concerned get access to these archives. I mean, you would think these are the victims, maybe you don't even agree with this. There are, of course, many other social groups, and at the end it's the society as a whole, but how to ensure that the people concerned have access, and what are you doing in this respect, and what are the main challenges you're facing, or dilemmas maybe also, apart also from the confidentiality issue we were discussing, but already physically, I mean, you said it's in Rabat, it's probably many things are written, and what about the target users?
Did you identify them? Well, actually, when we were thinking about archiving and preserving the records of the ERC and other records actually dealing with the period, we were mainly thinking about, the Commission was mainly thinking about historians, about scholars, researchers, because the Commission didn't do the work, as I said, of writing history, or writing a new way of looking at the history of Morocco. The Commission was establishing facts, trying to look to trying to find the truth about what happened, but not to put it in the whole context and the right history. And it said from the beginning, this is the word of the historian, and this is why the question of archival documentation was important at that time, because we knew that we need, and we still need, even some attempts have been made, we still need a new lecture to the history of Morocco, other than what we were used to have in school and the official lecture of history. The question of access, of course, it is a dilemma because of what was said in the morning on how to balance between the right to know, the right to access, and the privacy issue. Of course, as all, I guess, human rights, archives of truth commissions, the archives, the victims' files, for example, I mean, we will find information about individuals, private information, health information, many kind of information that make it very, very difficult for us to disseminate this information because it's private. Of course, we attempted to find solution. We attempted in kind of a guide. We wrote on possibilities of dealing with this access issue to find technical solution to how people can access, for example, simply by erasing names or things that may like things that from which we can know which person it is. and then give access to the broader public. During the mandate of the Commission, the files were open to victims. I mean, their own files were, of course, open to victims, and the case didn't happen. But I don't think we would refuse access to a victim if he's coming asking for its files. I mean, I don't think we would refuse access to him, but we will probably think about how we can, which information maybe he is not, because, for example, information on how the working group on reparation and how the Commission calculated the financial indemnization. We still don't know if this is open information for public. If this is an information that a victim, that we can give to a victim or a group of victims, because we noticed from the beginning, for example, the whole controversial issue of why this victim has been given more than the other. We gave the information on how, like the broader criteria on how the Commission calculated the indemnification, and based on what, like, for example, the number of years in jail, in prison, whether it's a direct victim or indirect victim, whether it suffered from the loss of opportunities, for example, because couldn't access his right to education or to school because his son or a girl of a victim. But we still haven't given this information to the direct victims.
So, do I understand you correctly? I mean, what you say now, from what I take from what you say, is that somehow the focus is still on the historians and the scholars to rewrite history, and then with this also to disseminate the information to the society, or so the victims as such, or remote areas, or people who don't read maybe and write, they are not that much in the thinking at the moment of the archive.
Well, the demand is not. I mean, we don't have a demand actually from victims directly. We with the demand, the actual demand is mainly from historians, mainly from researchers, from students. We are doing the work as well of disseminating the archive, and, as I said, the public information that was public at that time. But we don't have a direct need today. We don't feel it, at least now, from victims. But I said this is a question which was not actually resolved. The access, of course, is open, as I said, for staff and members of the Institute of the CNDH, because they are still, and we are still working on following up their recommendation and implementing specific programs like reparation programs, indemnization, financial indemnization, and so on. The other thing I wanted to say is that we are as well in front of, not a dilemma, but the fact is that there is a new law on archives now, and which is broadly saying and stating the ages, like the time needed for an archive to be open. And thinking that this the Commission archives is now National Archives, and it has to be so. Like put on the National Archives institution, it somehow now under the law of archives. So this is why I was saying we are still thinking maybe of, even if we have a law on archives, and the ages stated in the law are really long. I mean, it goes from 30 to 100, and we are saying today that this is a specific kind of archives, and we need to think about more like facilitating the access, not depending on what laws say necessarily, but depending on the spirit and philosophy of why these archives were created.
Nerma, also on this access issue, I mean, you described how you are working now on information centers and the idea of bringing copies at least of the material to the region and the societies concerned. I have two questions with relation to the one simply. Language, I mean, you mentioned millions and millions of documents. I imagine many of them English, I mean, or the relevant one in the local languages. And the second one, we saw, and you described it, not everybody agrees to get these copies and information center. What has to be considered, and how do you approach these difficult questions of how to do this work without further dividing the already heavily polarized societies in the region?
If I had that answer, my project would be finished already. But the reality of the Balkans is unfortunately such, and we have to find a way, especially as a legal institution, as the Tribunal, as a part of the UN, not to contribute to the further division and not to impose anything. And this is the approach that the President of the Tribunal has taken, that the Tribunal does not want to impose upon the states of the former Yugoslavia to take copies of these archives, that this has to be something that is accepted or wanted by the government. Now, the problem here was from the very beginning when we started the consultations. Overwhelmingly, the individuals you interview are positive with regards to wanting to see something like that in their countries. But the division starts when you begin discussions about the ownership, about the role of the government there. That's when you see from the victims and certain aspects of the NGO communities more negative response when you ask them what they think about the government involvement in running or establishment or financing of one such information center, because they are afraid of manipulations still with these documents. So when working on establishing those centers, you know, their mandate and the terms of reference and the role they play will have to be hammered out in such a detail as to avoid any possible manipulation with it. But in terms of the access issue to these documents, whether they are information centers or whether they are already available now, which they are, we had always had in mind a very diverse section of users. Obviously, as a legal institution, one of the primary audiences we had was the national jurisdictions, the national judiciaries, and how to ensure that they are able to continue using what we generated in their cases. Then we had the NGOs and the victims, academics, and then the general public. So the problem is the program or the idea of information centers, or even what we have available now on our websites and different databases, has been designed with that in mind. But the problem is that it is electronic. We are the world's first electronic court. When, you know, we, few years after the tribunal was established, banned papers in the courtrooms, and everything was on the computer. And then the problem is, how do you ensure that a vast majority of the population in the region of the former Yugoslavia is able to use it when they do not have such advanced technical skills to use and access that information? And that is something that has been divisive with the information centers, because when you speak to grassroots NGOs and the victim societies, they are quite adamant in wanting to see a hard copy of the archive being transferred to them. And having dictated to you, you know, all these petabytes and the millions of pages that we have, you know that it's impossible to provide it to anyone. So the problem we will be addressing in the lead up to the closure of the tribunal and the possible establishment of the information centers is to ensure, first of all, awareness raising among the people about what is already available. It doesn't even have to be in Sarajevo, in Belgrade, or in Zagreb. It's already available if you sit on a computer and learn how to type in a few basic searches. Having said, we're working, and as a side of languages, in all languages, majority of the material documentation has to be translated English, French, which are the official languages, and into the language of the accused or the victim community. So most of the cases are in 3 languages, and some are in 4, depending. However, what is not available in the languages of the former Yugoslavia are the transcripts of the court hearings, and that is a big chunk that is missing, which they would find useful. But what we are trying to do is to make our searches and databases even more simple to use. And again, it's a question of resources, to which we will come. So we're working on this idea which is called virtual tribunal, which would see us completely overhauling. You have all our transcripts publicly available now. You can download the audiovisual material, all the public decisions, public filings, including pictures, videos from the war, witness testimonies, etc. But it is in separate places, so it's not all cohesive. So what we are trying to do is align, for example, the transcript with the audiovisual record of the witness testimony and the documentation that the testimony supports. And it is a very amazing possibility, which really makes it a virtual tribunal. You are in a courtroom, just click on the document that is being mentioned, and it pops out, I don't know, CIA report from Falhi in 1995, while the witness is talking about it. But again, this will be depending on our ability to secure the funds to do this.
And as you rightly say, there's not only many challenges, but it's incredible how much is already, the possibilities we already have in terms of access and compared to. I would like now to give the audience the opportunity to come up with, certainly you have many questions, and I already say also that I decided to cut 10 minutes from our lunch break, because we have 2 hours for lunch and started also a bit late. So, I mean, you will have time now to ask questions. I suggest I collect them, 2 or 3, instead of answering all of them individually. There are microphones around, so. Yes. There's one with Thomas at the back, Thomas Ski. Maybe you say your name and institution. And if I may ask everybody to keep the questions concise so that we can make use of the remaining time. Yeah.
Well, thank you, Anita, but you're asking the right person to remain concise. My name is Guy Thomas. I'm from the head archivist of the Basel Mission 21, and lecturer in African history at the University of Basel. The whole question of access, I'm highly interested by access to the use of archives, and also relating that to the whole idea of what history and human rights could represent in these different societies we're talking about. Because in many respects, human rights are very much not a part of a sort of broad tradition of the way you cope with life in these societies. And if you're granting access or claiming to grant access to human rights relevant archival materials, you're also touching on a widespread history of fear. A history of fear in these countries, in these societies, where people are not used to opening up their minds to be able to touch on some of the very tricky issues of which have marked their histories. Now, to me, there's also, you're talking about granting access. What I'm interested in is, how are you going to instill a sense of wanting to democratize, open up access to information, and make, on the other side of the medal, the people who are supposed to access information really want to access that information? So a kind of psychological question here. The second one, you've established, Asmaa was telling a very interesting story about putting in place a good record-keeping archival system. Now, I've done that before in African countries, and the great pity is the long-term impact of deterioration. Once you put something in place, it's not maintained. Have you got a follow-up program?
Maybe we take, instead of collecting, I already contradict myself, take this question. Who would like to comment on this?
I don't know if the question was directed to me, but just to have some words on access. because I really get what you are saying in terms of if people really want to open what we have in their records. But it's a current debate in transitional justice countries where we operate. Some people want justice, others don't want. Some people want pardon and reconciliation, others want justice. I think it's the usual dilemmas we have. But for us as UN and human rights, I think we think about rights. We think about rights. And talking about the so-called right to the truth, we think that if it is a fundamental right, we need to do our utmost efforts to grant this right to victims. And that's why for me, the question of access can be facilitated through also international cooperation, where we have a role also. Because in general, at the country level, people did not know the procedures in place to claim their rights. For example, now we have treaty bodies, for example. If we consider, for example, right to the truth now is mentioned in the Convention on Forced Disappearance, people can use these mechanisms to claim their rights, even in terms of access, as the right to the truth is recognized. And if we have this right-based approach and this victim-centered approach, we don't have to think about do we favor the access, or it's not a matter of option. For us, it's a matter of rights. And this international cooperation serves also because, for example, we are trying to empower national institutions. And it's also their role to defend victims and take individual complaints. And for example, if we strengthen the capacity of national institutions to protect the victims, and if victims come to a national institution and requesting that his case is open, it's something we can be treated at the national level, but it can go to the ICC meeting. National institutions also collaborate with treaty bodies mechanisms where these issues can be discussed. And we don't use enough all the existing human rights mechanisms, both at the international and at the regional level. And our role is also to raise awareness on all these mechanisms so that victims can use it. That's what I wanted to say on access.
Thank you. Asmaa?
Well, thank you. Is it open? Thank you for the question. I completely agree about opening the history of fear. Why did I say and why I think that the thinking was on writing history from a different point of view, because accessing archives means finding at least, because what we have in archives is different lectures and different vision of facts, controversial sometimes, and that's why we didn't make history. We just said we need to find out more about what happened, and we read to give a specific analysis to these facts to exactly achieve what we call reconciliations. We're having a specific experience, a unique kind of experience, because we had a truth commission within the same continuity of the same regime, let's say, the same system. Maybe this is the difference between the Moroccan experience on truth commission and other experience. This means that we made the experience of knowing the truth, of the truth commission, of reconciliation, with the same institution. We worked within the same institutions, and we recommended and gave recommendation to the same institution in a way. And we still have to work with the same institutions in order for this to be implemented. So things changed the way of thinking changed, the political will changed in a way, but we still have the same institution as before in terms of way of work, of bureaucracy, let's say, for example, of many problems that didn't change because we just choose to do our experience within the same system and change things step by step. That's why the opening of the archives for us was important, extremely important for historians, and we still think so. Of course, and that's another problem of maybe transitional justice, and to think about what does really a victim want? I mean, within the transitional justice mechanism and within the transitional justice experience, we're talking about reconciliation, we're talking about compensation, which is a right, individual indemnization, which is a right. But what we can notice sometimes, and that's something we need, I think, to work on, is that's why I said we don't have a demand from victims, for example, because we knew that, or at least we can say that one of the main important things for victim was to access financial and other means of compensation, and is still for the state and maybe for political actors, for NGOs, the question of knowing the truth, of writing history, of giving some new facts, of achieving reconciliation, of preserving memory is interesting, and this is something we need to think about. Of course, I think it's not only it's not enough to say people don't ask for. It's important to say, as you said, we need to create the demand for. But I mean, it's not going to happen. I mean, it's going to happen, but within and in a group of people who are. I mean, we need to notice and know that illiteracy is a problem, for example, in Morocco. Accessibility is a problem for Morocco for institutions, because we have Rabat, Casablanca, Marrakesh, but we have the whole other part of Morocco, which access to institutions is very difficult. Access to school is very difficult. People have really basic needs and demands, and sensitizing about human rights is difficult. Sensitizing about, I mean, you may have people saying, so what? I mean, why are you still talking about that? Why are you still talking about the past? We are having real problem now. And that's the work that we need to, again, to do, is evaluating the impact of this. I mean, how reconciliation is really achieved. Is it achieved because we are now having some kind of consensus about the political, what happens politically in Morocco, and then some kind of reconciliation between political groups and the state? Or the reconciliation is more than that, it's reconciliating people with their country. And reconciliating people with their country means reconciliating more than those who were directly victims of what happened. I'll start.
Okay, for other people. There was a second part of the question where you asked how to ensure that the material is really well preserved on a longer term also, no? If I understood you correctly.
Yes,
preservation.
Maintaining.
Long term
Yeah.
consolidation of this foundation.
Yes. Who would like to make?
Well, from the Tribunal's point, maybe it's completely different than what Asmaa is dealing with, because there are already standards in place in terms of the preservation of the archives, which are at the moment, for as far as this new body that I mentioned, mechanism for international criminal tribunals, is being created. So that's I think it's a completely different level of the institution, because of course the tribunal will have much more resources and people working on that preservation than what we have in Morocco, for example. But I just want, if I can, for 2 seconds, just to add something to what my colleagues gave as an answer to the first part, which I think there's a huge problem for anyone who's dealing in this field, for the Balkans in particular. Not only how do you make your record public and accessible, but I think equally important question is how do you make these people aware that it is already public and accessible, because that is something that I notice in my interactions in the former Yugoslavia, and also international. I'll just give you a quick example. When in 2009, a raid by the officer of the prosecutor in Serbia uncovered 10 to 15 notebooks, densely written, which turned out to be Ratko Mladic's war diaries from 92 to 95. A segment of those diaries, which more or less completed the whole books, were filed as evidence in a number of cases publicly. But I had journalists, international and local, asking me to give it to them under the table when I had already created discs and discs of these diaries and giving them out, because it is already publicly available material. I think people somehow just assume, oh, this cannot be public, and the court will probably keep this under seal. So there is a lot of information that is already available, but people don't know. So in terms of how we try to rectify this for the region in this awareness raising, one of the projects that Outreach is doing is obviously working with the judiciary and the NGOs and academics to show them how to use the database that is already available. But also from the grassroots level, we're trying to set an example, because as a tribunal, you cannot tell people how to use your archive. You're supposed to give your archive, and you are supposed to decide how you want to use it in your work. That's the position. But from an outreach perspective, we're trying to set an example, for example, by making documentaries. So we are making documentaries only by using court record to show that you can actually make a 1-hour televised story of specific type of crime, like sexual violence and rape in World War, or a specific geographic region, through witness testimonies, documents, expert witnesses, exhumations, etc., etc. And in that sense, when you go and show it to people, they actually see how much of it is still available. People are not aware of all the different segments of information and types of information that go into one case, and the possibilities of what you can do with it. So it's one of the attempts.
So I suggest we take one more question, and then you have the whole of the afternoon also for further go into some of these issues. Yes, please.
My name is Tolu, and I work for the Office of the High Commissioner for Human Rights. I just would like to ask some questions about the need to balance access with protection. For instance, in the case of the international criminal tribunals, there are some classes of records that really have that are important to the major players in the transitional justice process. There are the witness, the protected witnesses records, for instance. They are the evidence that are put under seal. They are the evidence that were taken in closed sessions. And so we have those classes of records. They're the ones that, there are also the ones that are given out under Rule 70. And if in this process of collection, of preserving, and maybe, looking for funds to protect these records and to make them accessible in the long run, how would the cost be justified if some classes of records are never accessed, by those who have the right to know? And so my question would be, is there the possibility, because the process of declassifying, especially the ones that are protected by court orders, it's a long process, and it is not guaranteed, because at the end of the day, if the judges decide that they should not be released, they will never be released. So is there any effort, towards an open declassification over time when the victims or those who are indicated in those processes would not be, their security would not be challenged, by the declassification? For those of us who are activists, the challenge really is access, that is giving access to those who need the right to know in an operational context. It's not as easy because there are elements that are not very clear. And if, for instance, you want to give access to victims, for instance, and over time, how do you recognize them? What will be the authenticating information that will be required, to establish that they are indeed victims and not those seeking revenge on the victims? Thank you.
Okay. So, Nerma, this was a question directly for you.
I mean, it's a great question. It's a really important question, which I think has two sides of the answer. For now, that the protected or confidential information is made such as part of a judicial decision. So whether we're talking about doing it in order to protect the safety or the security of a witness, which I must put as an aside here, in the early years of the tribunal, in the early cases, majority of the protected witnesses came from the victim's side. And as our cases and our queues got more high level, you see more and more of the protective measures being given to insider witnesses who risk also an awful lot to come from that side and offer that part of the testimony. And the important thing to keep in mind is that in accordance with the tribunal's rules, once the information has been made confidential, whether it's the name, voice, or the image of the witness, or the contents or parts of the testimony of the parts of it, or whether it is about the documents that have been sourced from the states in the region or international governments as well, and many of whom gave the information under seal only, that order remains in force until a different order has been made by the judges or competent body to reverse it. And this is going to remain as such after ICTY transfers all of its duties to the Mechanism for International Criminal Tribunal, and will not stop holding being in force even after the mechanism itself stops functioning. And this, in that sense, it's important to know that this mechanism, the body that is going to inherit some of the tasks of the tribunal, will have the power, will not have the power to prosecute war crimes, but will have the power to prosecute contempt. Specifically bearing in mind that one of its key roles is to ensure that the information that is being protected for a reason, because the decisions to protect information of witnesses are made after the deliberation and the motions made by both sides, has to remain protected even after the tribunal. Now, in one of your sub-questions, a very important theme comes up which the tribunal is facing at the moment. In the early years, in our early cases, when people were not so familiar with the idea of coming to testify in war crimes trials, or with the idea of international tribunals as a whole, and nobody could really see how protective measures really can work, or where the loopholes are, that you would find in the early cases many more decisions where witnesses are granted protective measures than in the later cases. And what has been going on over the years is that a lot of evidence repeats as cases build up to the higher level. So already a lot of witnesses and their names and the information they have given, as well as material documents that were confidential in those early cases, one of the parties to the new trials has asked for the protective measures to be revised, and they have been revised, and on many occasions they have been made public. I want to give one very important example here, which is publicly known to those who follow.
Maybe a short
It's just
one.
a really short one, because it's a famous. For example, the minutes of the meetings of the Supreme Defense Council of Serbia, which were filed on record in the case of Slobodan Milosevic, but were filed confidentially, because that is how the prosecutor was only able to obtain access to them. However, once we came to another related case, that of Momčilo Perišić, majority, not all, but majority of the documents and the minutes of the Supreme Defense Council had the seal lifted from them. So it's in a space how the necessity to protect information changes in space of 4 years. But there will be information that will not be made available. Not everything will be public by the end of the tribunal, and there will have to be a decision-making body when there are requests to change the nature of that filing or that witness testimony. And it has to be dealt with case-by-case, on case-by-case basis, taking into account the safety and the security of the persons and the sources of that information. It will not be done as an overall decision just to lift everything after a certain amount of years.
Thank you, Nerma. And for the sake of your lunchtime, I would at this point like to interrupt our discussion. As I said, it's going to continue in the afternoon. Lunchtime goes until 2 o'clock. From what I heard this morning, what became obvious is that how important it is to be prepared for this issue at a very early stage, and I think the Moroccan case is a very good example, at least to my ears, from what I heard from you, Asmaa. I also heard how important it is really to create awareness around the importance of this issue, but also to convince the decision makers to really take care of these things and to mobilize the necessary resources. But we also heard from Nerma that much is already here, and from Mactar and Asmaa very clearly that you said it wordly, that step by step things change. So that's a good final word, I think. Thank you very much, Mactar, Nerma and Asmaa, for this interesting debate. Yeah, and wish you a good lunch.